Welcome to From Our Perspective. Today I'm joined by attorney Edmund Robinson to discuss a real estate dispute he helped a client resolve. Our client bought their dream home, but after closing, they found out the city would be installing a water pipeline through their property. We helped the client recover what they were owed and made things right. Edmund, thank you for joining me today. Tell me more about our client and why they reached out.
Yeah, thanks for having me. So our clients, they reached out to us originally because they had moved to Colorado and purchased their dream home. Beautiful views from the property they bought. Unfortunately, when literally the day they got to their property, found construction workers to be present on site for a municipal area here in Colorado.
And what is the duty of the sellers to let any buyer know about future development on the property?
So in Colorado, all sellers of real property have a duty to disclose any what are called adverse material facts actually known by the seller to the buyers. And now these adverse material facts, they're not limited to just things that may be there today. There are certain facts that sometimes pertain to potential future construction. For example, there's an explicit provision in the contract that says that if a seller knows of any government improvements that are approved but not yet installed that may become a lien against the property, that seller should disclose them. And that means that if you receive a notice of some potential construction that was approved, you have to tell your buyers.
And so as the buyer, what legal options did our client have in this case?
So as the buyer, what you first do is, you have to take a look at the contracts and what governs the relationship between the parties. And from there, your options are essentially to try and seek monetary recovery. Sometimes in contracts, you'll see what's called specific performance, and that's attempting to get the other party to perform their obligations in accordance with what's in the contracts. And in order to make those determinations, I think buyers should trust their instincts. If they feel like something's wrong, what you should do is just reach out, to an attorney and see if there is some kind of relief that you're entitled to.
And what steps should a buyer take to gather evidence to pursue a claim?
So when a buyer kind of has that instinctual sense that something's wrong, or if it's more severe, make sure you hold on to all your contracts. Make sure you keep them in a place where they're easily accessible. Compile all correspondence between the parties, emails, text messages, even call logs. Anything that you can think of that might relate to the transaction at issue, hold it, keep it in a safe place because your lawyer is going to want to see it.
And ultimately, what was the outcome of this case?
Fortunately, we were able to achieve a pretty favorable outcome for the clients, which resulted in payment to them of nearly $500,000.
If someone is watching and they've bought a home and they're in a similar situation, what advice would you give?
My advice to a buyer faced with a similar situation would be to call Robinson and Henry. We've got a large number of lawyers all throughout the state of Colorado who are well equipped to address the situation, provide you with advice on your options moving forward, and we'd be happy to help you in your time of need.
Great advice, Edmund. Thank you for sharing your perspective.
You're welcome. Thanks.
If you've discovered issues with your new home that the seller didn't tell you, our team can help you get the compensation you deserve. Reach out to us for a case assessment on our website or give us a call.